also an informal business entity. A partnership is a way to go. It makes the band feel secure. It makes them get the business thing out of their mind. It's something that can be done relatively inexpensively, and it makes them feel good about being a unit. These days, it's not just about making the music, it's about getting things done. They need to feel like they're doing something. Even before they come to you, they need to feel like there's some kind of structure to them, or else they can't do their artistry. I found that a lot of bands will stop recording, will stop writing until their relationships with the other band members are codified in copyrights, trademarks, and in sometimes band partnership agreements. Either way, it's a tool we have. A product we sell as attorneys is a band partnership agreement or some kind of solidifying of their relationship. When the band walks through the door, or the singular artist, usually the leader, walks through the door, I let them know in my standard engagement letter about these things, but I don't force it down their throat. For example, trademarks, we're going to get to in the next section. Trademarks is something that the band should look at if they've got a unique band name or logo. However, if they've been using it, in the United States we have what's called use trademarks, use copyright, which differs from the other countries, but we're protected under what's called the Berne Convention. If they've been using it in interstate commerce, even intrastate commerce, we have an argument of what's called first use. So that means the band can say, listen, we have proof, we came out with an album, it's got a name and logo on it, it's in the world. It's use they have to show when it was used in case there's a challenger in the future. About trademarks, understand this. To challenge or to keep ownership of a trademark, you don't have to register it in the United States. Use is enough to have it, to be the owner of it. But to actually do anything in court, you've got to actually register it first, even if you're second in time. For example, if I created a restaurant right now called McDonald's, and I go to trademark it, very unlikely that I'd even get it trademarked. But if I claim that my use was prior to Ronald McDonald's, I would have to first register mine now, and they would, of course, challenge that, but I at least have to try and get a conditional registration, and then I could challenge. But it's like a ticket you need to get in the door. With bands, you can offer them the trademark service in the beginning, but that's not the... I offer them all the services, and then they can pick and choose by their financial ability what they're looking to spend money on. Trademark, not so important. Copyright is important. The Copyright Office has changed in the last, I'd say, 5 or 6 years with regard to how they let you copyright. It used to be that they'd come in, you'd use Form SR, which is for sound recording. They give you a cassette tape or a CD. You send the cassette tape CD down, and it deals with the ownership of the copyright. Now they have forms you do strictly online, Form CO, which is in here as F. Let's switch to F for a second. Flip to section F. This is for copyright registration. Anybody here written anything before with one of these forms? Okay. The forms now, they make it very simple to do. Copyright registration is important because you're dealing with who's going to own the product, the song, how is it going to be owned, and it could be very well the biggest dollar event for your client in the future. This is the formula for Coca-Cola, their copyrights. This is their bread and butter. Who owns this copyright? So a lot of my work comes with local studios who have clients come in to record music. And you'll get this a lot if you advertise to your local studios and recording studios. And clients will come in, they want to do a jingle or a commercial, and the studio tech winds up doing some production work actually on their product. And he says, listen, I'm doing some work on this, and I want to know if I have any right to any ownership in the copyright because I really think it's going to do well. And it all depends on what the original relationship is. That's why you do a studio production agreement. So usually the artist coming in is doing it work made for hire. They're paying for the time, and then somebody is working on it. If there's two ways to do it, copyright ownership in the person who's copywriting it themselves in their name, or it's a work made for hire. A work made for hire is I come in with the idea, I have a song that goes like this, da, 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 and somebody will put it all together for you and write the song. If it's a work made for hire, you own it and somebody else did the work, but you paid them to do it. That relationship should be set forth in the beginning because otherwise the guy who did the work, a musician to put it together, or who wrote all the stuff that backs up your da-da, is going to say, no, I wrote this thing as soon as it gets big. So those issues need to be addressed in the beginning. The person who is the person doing the work can have their name on the copyright form as a person credited, and you'll notice on the form it's either work made for hire or it's original work done for that person. This form CO takes into a lot of the former forms. Used to be there would be one for literary, there would be for PA, was for performing arts. You look at section 1, work being registered. Then the form SR was the third one down in section 1A, sound recording. So now they've all put these in one form, which I think is a good idea because the separate forms are confusing people for copyright. Then you'll see there's different areas. Is it a volume? Is it a series, like for if it's a book, like the Harry Potter series? That would be section 1A, literary work, the title, Harry Potter. Then there would be volume 1A, Sorcerer's Stone, and so on stuff. Once you get this form filed, I think the current is $35 still, you have a copyright that's registered. You can then feel free to go out and do things in the world with the song. Your artists will say, well, I did the poor man's copyright, which is mail themselves a copy of the product in a sealed envelope and never open it to show a postmark date when it was put into commerce. You don't necessarily need to do that. It's one way of showing that it existed, but that's ridiculous nowadays. So when they come in, you should guide them against doing the poor man's copyright and ante up $35, hit the internet, and do it themselves if they like. Or what I do is $125 plus $35. Come to me for $125 legal fee. I'll take care of this for you. Why? Secretary fills out a form. It's not hard to do. A lot of attorneys charge their hourly rate to do copyrights, and they charge about an hour to do each copyright form. You're never going to get starting clients that way because they just can't afford it. So I do $125. You come in per song. If you have a whole album, 10, 15 songs, I'll do each song. I'll do the whole thing for $1,000, and you can make payments. The copyrights come in, and what you do is you put yourself as the list. You ask them first. You put yourself as the name listed for the copyright contact. This way, anything that happens with that copyright in the future goes through your office. And then you at least are able to communicate with that client more about the copyright as you try to sell it. A short little lecture here about copyrights. Once you own it, it's like a product. You want to get in touch with, you have a bunch of songs you own. This is called your catalog. Catalog of songs you own, catalog of copyrights. They need to be, if they're popular, they need to be administered. So you look for a publishing company to publish them and what we call exploit them, administer that catalog or that song and get it out there in the world. There was a movie called Romancing the Stone with Michael Douglas and I want to say Eddie Kramer, but it's not Eddie Kramer. It's not Eddie Money. Eddie somebody did a song, I'm Romancing the Stone. He had written that song probably 12 years earlier, but it was in a catalog. So when the film company sent out to Peer Music and to other publishing companies, film coming out, Michael Douglas, whatever the other woman name is, same one in the War of the Roses, that woman. Kathleen Turner, called Romancing the Stone. It's about these adventurers, Indiana Jones type folks looking for a diamond and they fall in love along the way. So they look through everything and they find a song called Romancing the Stone. The same guy who sings Rock Onto Electric Avenue, whatever that guy's name is. He writes this song years before. It's in a catalog of music. It gets picked up. He tweaks the lyrics a little to fit the movie, and now a guy whose career was pretty much dead comes back up, and he probably made the most money he ever made his career off of that song.